In this module, we finish off our discussion of the different mechanisms of judicial review by looking at a collection of different forms of bad behaviour. So we're going to look at a little bit of time at unreasonableness, we're going to look at fraud, we're going to look at bad faith, and in the readings this week we're going to look at a new sort of problem that's emerging, which is the use of privative clauses to try and exclude review altogether. So unlike previous elements of judicial review that we've looked at, these usually involve some kind of fault or culpability on behalf of the decision maker. Generally speaking, admin law is really focused on the process itself and making sure the process is fair. But sometimes the decision maker will make a decision that is so outrageous for various other reasons that the courts will intercede, and this is what we're looking at here. Again, it's worth comparing the idea of judicial review to other areas of private law, where generally speaking it doesn't really matter why you do what you do as long as you obey the letter of the law. So in commercial contract law, people can behave as badly as they like as long as they operate consistently within the rights and powers that are assigned to them under contract. Now that's quite different when we come to consumer contracts, and you'll remember that there's been legislative intervention to prevent the operation of unreasonable contract terms. For instance, a jurisdiction clause. This is one that was used quite often until recently by telecommunications companies that said, if you want to sue us, you have to sue us in Western Australia. For no apparent reason except for the fact that most people don't live in Western Australia, and for most people on the East Coast, it's an extremely costly exercise to try and litigate in another city on the other side of the country. That's a good example of an unreasonable contract term. So generally speaking, commercial contracts, business to business, you can be basically as big a tool as you like as long as you're operating within the law. There's a little bit of an exception there if you're dealing with consumers, but when we come to admin law, as you've seen, the standards are much higher because you can't freely enter into a contract or a relationship with an administrative body. It's kind of imposed on you. So the duties and requirements tend to be a little bit more stringent, a lot more stringent. Okay, so we've looked at the procedural stuff, we've looked at the jurisdictional error, we've looked at natural justice. This week we're looking at a grab bag of other things. Probably deal with the last two first, because they're simple to deal with. Fraud under section 5, subsection 1, subsection G of the ADJR. It's pretty obvious that if you've got fraud on behalf of an administrative decision maker, that's going to invalidate the decision. It's very rare that happens. It's very rare that it's provable, I guess, but that makes perfect sense. And similarly, bad faith, which is section 5, subsection 2, subsection D, is a situation where if you can prove it, if you can prove there's some kind of bad faith there, that will also invalidate the decision. Now, the case to go to in terms of what we mean when we talk about bad faith is SBBS and the Minister of Immigration. And it includes an issue of personal fault. So bad faith is not a situation where it's an objective test or a reasonable person wouldn't do this. It's actually saying that a decision maker was operating in bad faith. So it has to be a matter of personal fault. Honesty is often crucial, but it is not required. You can be operating in bad faith non-dishonestly just because, to use the technical legal term for it, you're being a tool. And in those circumstances, you've got bad faith. You're not operating in a fair way, you're not operating in the best interests of everyone, you're not considering the public interest, you're not balancing this and this, you're just making a decision because you can, and you can really mess with someone to do it. And it doesn't need to be there needs to be a mental element to it, but it doesn't have to be dishonest. But if it is dishonest, that's clearly a problem. And it can be reckless. It can be a situation where someone just doesn't care about the people they're making decisions about, and they just make a decision which has it affects them in a way that manifests bad faith, that doesn't necessarily mean that they deliberately went out to do that, but they should have known in those circumstances. So bad faith is really those situations where you've got petty bureaucrats making petty decisions without really caring about the consequences of their actions. Now that's a little vaguer than the other areas of review that we've looked at previously. And it's one of those situations where the famous quote from Justice Potter Stewart, who said, "I can't define what pornography is, but I know it when I see it." And bad faith's a bit like that. It can be hard to lay down a definitive definition of what it is, but usually when you see someone behaving like a bully, behaving like a thug, embarrassing or humiliating people, publicly making decisions that benefit one or the other, that with no necessary sense of fairness, except you just don't like someone, those are all situations where bad faith operates. And there is, moving on to the next ground, which is unreasonableness, there is a kind of a blurry line between bad faith and unreasonableness. And unreasonableness is the last sort of principle that we'll look at here, and it's the one that's been the most problematic. It was introduced in a case called Wednesbury, or Wednesbury, if you want to spell out all the letters that are in it, in the UK, and that was distinctive in it was a case that recognised the principle but said it didn't apply in that particular case, and that was a licensing authority licensing cinemas. So we can't really go to the facts of Wednesbury to find an example of what unreasonableness is. We can find an example of what it wasn't, but it was a situation where the court said, look, it doesn't apply in this case, but we think there probably is another ground where a decision is so unreasonable that no other similarly qualified decision maker would have made it. And it's fairly extreme in those circumstances. However, this got recognised in the ADJR in Section 5, Subsection 2, Subsection G, so we've got it, and what do we do with it? And there's been a long history in Australian jurisprudence of basically stepping around the issue of unreasonableness, not wanting to throw it away, apart from the fact that it's in the Act, but also wanting to restrict what the meaning is. And possibly, the Justice Dixon in the Avon Downs case in 1949, which is previous to the ADJR, laid down a very sort of definitive test where he said we're just never going to use it, basically. But we've moved a lot further from there, and obviously it's in the Act, we can use it, but it almost never does get used. So we're talking about capricious, inappropriate, oppressive use of power. How this is different to bad faith is an interesting question. And I suspect if something is so unreasonable to fall under the unreasonableness test, it would probably fall under the bad faith test as well. And it's another one of those ones that you just sort of double barrel. You use both, I guess. Some examples, possibly the most commonly used example is the unequal distribution of a benefit to a certain class of people, or unequal distribution of a penalty, I guess would be the same. So that's the Sunshine Coast Broadcasters case. And that's really a situation where you have a power to fine everyone, but you only fine one person out of that group. Everyone who leaves one of those crazy council bylaws that says if you leave your bin out for more than one day after the rubbish has been removed, you get a fine. Yeah, it's crazy, but some places are trying to do that. But you find at the end of the day that everyone's leaving their bins out for 2 days, but only specific people are being targeted. That would be an example of unreasonableness. Also, and the same with a benefit. If you've got where you've got a license that's issued and there's no process to it, you say, oh, you can have a license, you can have a license, you can have a license. That might be bias as well, but it may not be bias. It might just be someone's just seemingly randomly assigned that benefit. So that would be an example of unreasonableness. The other example that's often used is a decision's out of proportion to the aims of the power. So you've got a situation where very, very harsh punishments are being handed out. And I guess equivalently, you could have, fantastic benefits handed out to someone. Someone's land is resumed by the council and suddenly they've given them a heap of money, way in excess of the value of the land. I've never heard of that happen, but it could feasibly happen. And often if that did happen, you've probably got a foundation of bias there as well. But maybe it doesn't. Maybe someone just goes crazy one day and decides to, give a huge benefit or a huge penalty. Another phrase that's used in the unreasonableness cases is the lack of plausible justification. So basically, it's a very, very high level test. We've got lots of cases where the judges all say, we were very, very reluctant to apply this, because there's a real danger that when you start talking about unreasonableness, that you start moving into the field of merits review, really. You're starting to actually assess the merits of the decision. And in fact, many of the distinctions that are used around what is unreasonableness often get back to, well, it's taking into account irrelevant considerations. It's making an error in law. It's failing to take into account relevant considerations. They're falling into other areas of judicial review anyway. So it's very hard to establish cases where you have unreasonableness by itself. But I would suggest the ones that are the clearest are the unequal distribution. You have to hand out this equally, and suddenly someone gets something more than someone else does. And the situation where something is out of proportion, where someone's getting a huge fine that no one else ever gets. They're getting a huge fine because someone wants to throw the book at them over it. And again, there was something recently, I say recently, it was probably about 5 years ago now, in Victoria, where the little used powers to punish people for taking things out of the hard rubbish collection were used against someone in a very harsh way. They issued the maximum fine they could for someone for taking a lamp out of someone's hard rubbish, and that got appealed, and it was not a reported case, but the judges thought that was a ridiculous decision in that particular case. All right, so unreasonableness, I'm sad to say that I can't give you a nice, neat definition of where it does apply, because most of what we've got from the cases is when it doesn't apply. But it's been left there, I guess, as a bit of a reserve for the judges, where if they hit a situation where they can't apply one of the other grounds. And in fact, there has been some, and this is mentioned in the notes, some extension of unreasonableness to illogical decisions or irrational decisions. And that's because some of the legislation specifically removes unreasonableness as a ground of appeal. And that's, for instance, the Migration Act basically says you can be as unreasonable as you like, because unreasonableness is no longer ground of review. So the courts rankling at this, of course, are saying, well, maybe illogicalness or irrationality is also a ground. Basically, giving a very clear indication to the legislature that you can't just weasel out of the operation of Section 5, Subsection 2, Subsection G, by removing it. The courts will find some other way to introduce a ground of judicial review or jurisdictional error that will apply. And that brings us, I guess, to the reading this week on privative clauses. And that's a good example of that continuing battle between the courts and the legislature, as the legislature tries to weasel out of accountability for its decisions. And again, this brings us back to some of the fundamental themes we talk about in this course, where we talk about, on the one hand, people have this kind of very simplistic idea of democracy, that basically, if you vote a government in, they can do what they like. They can ruin everything that they like for their term in government, because you voted them in, therefore they can do it if they like. Versus the actual foundation of the Westminster system that we operate on, which is representatives are limited by law. They're limited by rule of law. And when they are accountable, sometimes they say, they resist this and say, well, that's not very democratic. No one elected the judges. How come a judge can overrule what an elected official or an administrative appointee of an elected official has to say? And again, that's a very, very simplistic, way too simplistic idea of how the system operates, because the system only works because of those checks and balances. You can't just go in and start throwing those out, because you then no longer have a democracy. You only have a system where people are free, as I think Voltaire said, that only free once every 3 years on the day that you cast a vote. And it's this is one of those areas where administrative law is extremely important, because it's something that protects people until they can have a chance to vote that particular set of representatives out of Parliament again, if they behave in ways that are unreasonable, oppressive, bad faith, and so on. So that draws this particular part of the program to a close. We focused on some of those grounds of judicial review. Of course, they inform merits review, but merits review doesn't require grounds. But of course, if you had any of these sorts of unreasonable, oppressive, fraudulent, bad faith situations, they would form the foundation of a strong argument when you went to merits review in any case. Moving forward till the end of the term, we're going to start looking at some of the different mechanisms of accountability that are in place that don't involve litigation, that involve high-level forms of legal accountability. So next week we'll start on commissions of inquiry and so on.